Welcome back to OCLRE's series on brief writing. Today we are joined by Professor Jennifer Cupar of Case Western Reserve University School of Law. She is the Associate Dean for Academic Affairs and a Professor of Lawyering Skills. She currently teaches professional responsibility and previously taught legal writing, leadership, experiential learning, advocacy, and professionalism, LLEAP 1 through 2, LLEAP 3 on litigation, race, law, and society, and the Federal Judicial Externship course. Her session today will guide you through the process of developing your argument and determining how to outline a roadmap to get you to your point.
All right. Well, thank you so much. I'm happy to be here to talk to you about building the argument roadmap. So I've got two objectives for you today. First is to learn how to structure your argument so that you emphasize points of strength and lead the reader to the conclusion that your client should win. And also how to craft persuasive point headings that lead the reader through your argument. Before we go into the tips, I want to talk about a few words that I'll be using today just to make sure we're all on the same page about how I'm using these words. So when I refer to the word issue, I'm talking about an entire claim or defense that a party might have brought. So for example, defamation is a claim. When I say element, I'm referring to one part of the test that the proponent of that claim must satisfy in order to succeed on the claim or defense. So if you go back to defamation, it has 5 elements: a false statement published to a third party about the plaintiff, harm to the plaintiff's reputation, and fault. Now, I know that you may, and some of your issues, be using or referring to what are called factors. And those are things that courts consider in determining whether a party can prove a claim or defense. They differ from elements in that they're not required. Courts weigh factors, but the same principles I'm talking about today in terms of organizing an argument with respect to an element would also apply to factors. And then finally, when I use the word point, what I'm referring to are the specific arguments that you make in support of showing that an element does or does not exist. All right, so let's begin by looking at how you organize an argument. And when you do that, you've got to think large scale organization, mid-level organization, and small scale organization. So let's begin by looking at large scale organization. And the general rule is that strongest issues go first. And you're going to see that throughout at all levels of the organization. The fallback rule is always that your strongest goes first. And I'll tell you why in a second. There are possible exceptions in a brief, and we'll talk about those as well. So threshold issues, logic, and if you're the appellee, you might decide to go with something other than your strongest issue first. Well, on an appellate brief, they're going to have to go back and look at what the trial court's reasoning was. They have to have a really good understanding of what the law is on that issue. They've got to be able to poke holes in their own arguments. I mean, I constantly tell my students that you have to know your opponent's arguments better than your own arguments. And if they're in that position of really understanding what their opponent is going to say on an element, then they can use that information to kind of judge which elements are their points of strength and which ones they maybe are going to have the most trouble with convincing the court. So why do we put strongest arguments first in a brief? Strongest issues and strongest arguments and points. And that goes back to the psychological principle of primacy, which is that people tend to remember best and are most influenced by the information that they hear first. And let me give you an example of that. So if I were to put the word red on the screen in the color red, and then I were to ask you to think of a fruit, you're very likely to think of a red fruit, like a strawberry or an apple. And that's because you were primed to think of red fruit simply by looking at the word red on your screen. And that principle applies throughout your entire brief. And what that means is that the beginning is always going to be a point of emphasis. Your first section, your first paragraph, your first sentence, your readers are going to pay most attention to those. That's why when I teach brief writing with my students, I use what I call the I win, you lose approach. In another session, I believe you learned of this as the positive negative approach. I actually prefer I win, you lose to positive negative. And the reason why is that I believe strongly that you begin with your winning issues and then you turn and address your weaker arguments or your opponent's issues, but you don't treat them as negatives. You should articulate even your opponent's issue in a way that supports your client's position. So you're making your argument as to that position rather than articulating your opponent's argument, which is why I like to refer to the positive negative approach as the I win, you lose approach. So there are exceptions, and this goes to one of them is the primary exception, which is threshold issues. Once in a while, you have an issue that you must address first. And that would be your classic example of that is jurisdiction. So if your court doesn't have subject matter jurisdiction, for example, they are not allowed to even address the substantive issues in your brief. So if subject matter jurisdiction is at issue in your case, you have to address that first. So if you're the party who wants the court to hear the claims or defenses, then you've got to prove that the court does have subject matter jurisdiction. And then if you succeed, the court goes on and reads through and looks at your substantive issues. If you're the party trying to argue that the court doesn't have subject matter jurisdiction and you succeed, the court is done and they don't look any further. Personal jurisdiction as well works the same way. They would address that first. Sometimes logic will dictate putting an issue that might not be your strongest argument first. One pretty common example of this is jury instructions. So say you've got an argument that the trial court made a mistake in giving a jury instruction. Often the court needs to understand the underlying substantive issue before they look at whether the trial court instructed the jury correctly or incorrectly on that on that issue. So you may put the substantive argument before the jury instruction argument, even if you think you've got a much stronger jury instruction argument. And then finally, appellees might decide for strategic reasons to simply follow the structure of the appellant's brief. And that's because you won below. If you're the appellee, you're the winner. And especially if you feel like you have very strong arguments and you think that there's really not a chance the appellant is going to win, you may just want to simply track your opponent's organization and explain why your opponent loses on each of the arguments that they're presenting. I still believe that the default rule is that you should put your own best arguments first, and you typically don't want your opponent's structure to dictate yours. But there are times when you may decide to do otherwise and simply track your opponent's organization. All right, that takes us to mid-level organization. And this is when you've decided what issue you're going to address and the order you're going to address them. And say you have multiple elements or factors that are in dispute on that issue. Then you've got to decide the order in which you'll address the elements that are in dispute. Once again, you're going to typically begin with your strongest element first. Begin with your point of strength. Possible exceptions, again, are logic sometimes dictates putting an element first that may not be your strongest. An example there could be, say you've got a really good argument that damages on a claim were inappropriate and that the jury awarded, for example, far too much money. Usually you're going to have to establish liability elements first. Go through and address any liability elements before you get to damages, because it just makes more sense to a reader. And again, an appellee might decide to just track the organization that the appellant used. One side note here is that you probably don't want to end on your weakest element. And that's because the end is also a point of emphasis for a reader, and that's the recency principle. Primacy and recency are two very important psychological principles that can help you emphasize your points of strength and kind of minimize the weakest points. And by that I mean put your best stuff first and last, and kind of bury the things you're the most worried about in the middle, because the middle tends to be the place where the reader places the least emphasis. When you are analyzing an element, this is when you use what you've heard in other sections, the structure, the CREAC structure, or you might have heard of it as IRAC or some other mnemonic. But I like the mnemonic CREAC because to me, it covers all of the things that a reader would need to understand about the element. You begin with the conclusion that you want the judge to reach on that element. You tell the judge the rules that apply to that element. You explain those rules by giving definitions, examples of things that meet the rule, examples of exceptions. You may include a couple of illustrations of cases applying that rule so the reader can understand how those rules have been applied in similar facts, cases with similar facts. And then you finally apply the rule to your facts and lead the reader to the conclusion that you stated in the beginning, help them understand why those rules apply to your facts in a way that make your client the winner. And you briefly conclude, again, by reminding the court of the conclusion that you want the court to reach. All right, then we've got to think about small scale organization. And at this point, we are down to the points that you are going to make to support your elements. So the arguments that you're going to be getting into. And once again, strongest typically goes first. And once again, I recommend the I win, you lose order, meaning begin with your own winning arguments and then address whatever counter arguments you feel you have to address, with logic being an exception, and again, appellees being an exception that you might end up dictating that you take another approach. Paragraph structure is important to think about. And I stress this to my students, my law students, again and again, all year long, which is they must begin paragraphs with what I refer to as thesis sentences. And I like the word thesis rather than topic, because I think in a brief, topic sentences do not do what you need them to do. You don't simply want that first sentence of a paragraph to state the topic that you're going to address in that paragraph. You actually want to make a point in that first sentence that is in favor of your client and that moves the ball in your client's favor. So that's why I never let them refer to these sentences as topic sentences. I tell them you have to think of them as thesis sentences because they have to make a point. Then you've got to focus on that point. Every sentence and idea in that paragraph has to relate to the point in the thesis sentence. If it doesn't, it belongs in another paragraph. Or if you truly think that it does support that thesis sentence, but it's not clear why, you need to clarify it. Every single sentence in the paragraph should help prove the point that you made in the first sentence. And you should think of your paragraphs as an inverted triangle. You want to begin with broad points and then move to narrower, more specific points. And let me give you an example of that just in terms of a rule paragraph. So in the CREAC structure, the first paragraph that you're going to have after your conclusion paragraph is the rule paragraph. And you start broad by stating the rule that applies in that section. Then you get a little bit narrower by potentially giving a definition of terms in that rule, some examples of things that meet the rule. And then you get even narrower and address exceptions to the rule. That is an inverted structure. You begin broad and get narrower. A very, very common mistake that my students make when they begin in my legal writing class in law school is that they tend to end a paragraph with what should be the next paragraph's thesis sentence. That does not work. It's not an inverted triangle. You end up with a base at the bottom of your triangle. It takes away a thesis sentence for the next paragraph, and it is very confusing for the reader because you have now added an idea to a paragraph that does not fit the concept that you identified at the beginning of that paragraph. So really be on the lookout for when you've done that and make sure you move that sentence to the beginning of the next paragraph. All right, what do you do with policy? In an appellate brief, policy is often very important. And the general rule, though, is that law goes before policy. If there are rules and cases and legal principles that have been established and that apply to your issue, the judge wants to know what those are before you get into policy-based reasons to support your client's position. However, you often can integrate some policy into your legal arguments. For example, there's maybe case law out there explaining why a rule is the way that it is. And that explanation and justification for the rule might support the position and the arguments that you're making in support of your client's position on an element or on an issue. So if that's the case, then integrate that policy-based position into your legal analysis. You can put it, for example, at the beginning of your argument and where you're identifying all of the elements that are at issue and explain what the justification for the rule is. And then throughout your analysis, explain why your arguments support the reason for the rule and why that supports a conclusion in your client's favor. Now, if you're dealing with a novel issue, an issue that your jurisdiction has never addressed, or maybe no jurisdiction has ever addressed, then policy might be your strongest argument. And you actually do begin with policy because that's really all you have. So again, general rule, law before policy, but there may be some exceptions to that. All right, let's move on to point headings, which are really the roadmap for everything we just talked about. What I've seen in general, lawyers do not use enough headings. Often I'll read briefs that go pages and pages without any break for the reader. Readers need that mental break. They need the white space that a heading creates. And they also need them to help understand how you've categorized your information and follow the analysis that you've chosen. You can use headings in your statement of facts. You might have use headings to identify key events or topics in the story. And certainly in your law and analysis section, your point headings are extremely important. You use them to identify the legal issues that you're addressing, the elements or factors that are in dispute. And then even within an element or a factor, I highly recommend using subheadings to identify key points that you are making in support of that element or factor. One of the reasons that headings are so incredibly helpful is that they create opportunities for emphasis. The heading itself is a point of emphasis. You're going to use some typography to make that heading stand out, whether it's bold or underlining. It's got white space all around it, so it jumps out at the reader. Also, the first sentence after the heading is a point of emphasis. Readers pay more attention to information that appears right before or after a mental or even physical break. And by physical, I mean, say the reader's reading a section, reading your brief, they need to take a break, something comes up. They're probably going to try and finish reading an entire section. They'll put it aside. They'll come back to where they were, And now they're starting at a section, reading the heading first, and that is now the first thing that they're reading. And again, back to the idea of primacy, that is now a very important part of the brief for them. That is a point of emphasis. So that's why headings can be really useful tools for persuasion. It is definitely possible to overuse headings. It doesn't happen very often, but once in a while I'll have students, because I do stress how important they can be they are and how helpful they can be. They sprinkle their, one element in a 5-page discussion has 6 headings. And I'm like, that gets too choppy for the reader. Unless there truly are 6 very clear separate sub points or sub elements, and it would help the reader to see and why you're breaking it up the way that you are. I mean, it's just sort of a field test. There's honestly not a great rule of thumb for that. And it always goes back to the legal rule that you're dealing with. The legal rule and how the courts have applied and interpreted that rule is always going to dictate your structure. And so it may be clear from court opinions that a rule for an element can be broken down into 2 distinct subparts. Well, you're going to have 2 distinct subpoints and subheadings in that situation. On the other hand, if it's a rule that's factor-based and there's 10 factors, you may not want to have 10 little subsections for every single factor. That might get way too choppy. So you have to understand how the rule is broken down and then think about whether it flows. You have to kind of think about the flow for the reader. Here's some of the basics that you want to keep in mind when drafting point headings. 3 lines or less, and I really should have put in bold or less. You really want to aim for less than 3 lines. And the reason is that if they're longer than that, it's telling the reader what is coming up is very difficult. And so you've already put your reader in kind of a bad mood because they're expecting this to be complicated and hard to understand. The really important rule about headings is that they should tell the reader what the section is going to be about simply from reading the heading. They should understand the argument in broad strokes, the argument that you're going to be addressing in that heading, in that section. And then finally, use a single complete sentence for a heading, not topical headings in the law and analysis section, not multiple sentences, one single complete sentence. You want your point headings in the law and argument section to be argumentative. By that, I mean, use them to make a point in favor of your client. And the reason that you want to do that is that if you were to collect all your headings in the table of contents, you want that table of contents to begin to persuade the reader in your client's favor. They should be able to read the table of contents of your brief, understand what your arguments are, and begin to be persuaded by those arguments. They should give the reader a concise statement of your best points. They should help the reader understand the relationships between different sections of your argument. They're also, on a practical matter, finding tools. A reader may have a question, for example, on going back to defamation on the fault element. And that's the sticking point for them. Well, they're going to use your heading to go back and find that section of the brief. And finally, you use your headings to present your arguments in very easy to digest chunks. So the formula for argument point headings is that they should identify the conclusion that you want the court to reach or an action that you want the court to take, and the reason why the court should accept that conclusion or take that action. And usually that means you're going to have to include the key facts that support what you're saying, the conclusion that you're asking for, or the action that you are asking the court to take. Your number one rule for point headings is that the reader should be able to read only your table of contents to understand your argument and also hopefully be persuaded by it. So let's take a look at an example to see how these principles play out. So this is a set of subheadings in a case where a student sued a school district for failure to protect the student from peer-on-peer harassment. And the question here is whether the school district was deliberately indifferent to the harassment. So you can see just by the letter B that this was the second section in the brief. So for whatever reason, the writer chose not to put this first. Must have decided that it was their second best argument, or logic dictated that another issue had to go first. If you look at the top level heading, you can see the action that the writer wants the court to take, which is granting summary judgment to the school district. If you continue reading that subheading, you can see the reason why the court should take that action, and that's because the student does not meet one of the elements of the claim, specifically that the school was deliberately indifferent to the harassment. If you go down to 1, this is one of the parts of one of the elements of the deliberate indifference test, whether the harassment, whether the school's response to the harassment was clearly unreasonable. And you can see from subheading 1 that the conclusion the writer wants the court to reach is that the school's response was not clearly unreasonable. And then finally, these subheadings are very specific reasons supporting the conclusion that the writer wants the court to take. These are the reasons that the writer is arguing that the school district was not clearly unreasonable. The school reasonably tailored its response when it was aware of incidents. When the school learned of harassment, it conducted investigations promptly and thoroughly, and the school promptly modified methods of dealing with the harassment once it knew that those methods were ineffective. So this is a good example not only of point headings, but just understanding how to structure an argument. Again, thinking through where do you put your issues, and then how do you break them up? How do you break an element down into specific points that support that element? And then crafting those point headings to be persuasive and to lead the reader to the conclusion that you want them to reach.